Hello, everyone. Welcome. I'm Carolyn from Workable. Let's get started in just about 30 seconds. We're just going to wait for everybody to join. So give us 30 seconds and sit tight. All right, it looks like most of us are in here. So, good morning, good afternoon, and good evening to everybody who's joining us from across the world. Welcome to CCPA and Recruitment, What You Need to Know. Today, we're going to explore CCPA and all of the uncertainty that's surrounding it. We'll cover what you and your teams need to do to be compliant and stay compliant within CCPA. And we'll also touch upon what you don't need to do right now, but might need to prepare for if future laws are passed in the US. I just would like to start with a bit of quick housekeeping. So you will have the opportunity to ask our expert, Alan, your own questions today, and you can send them in the question box at any time during the webinar. Just to make sure that's working properly, can you please type number 1 into the box right now? Awesome. Thank you, everybody. I'm getting some feedback that it looks like my video isn't great. Let me just see really quick if I can fix that. 1 second. All right, hopefully that's a little bit better. So great. I also will let you know that the slides and the webinar recording will be available afterwards. So everybody who is registered will be sent those. Okay, so first I'd like to introduce myself. I'm Carolyn. I head up events and webinars here at Workable. A lot of my time is spent speaking with recruiters, HR pros, and leadership people who need to grow their companies. I work a lot to create spaces like this to talk about recruitment, HR, and the future of the industry. And I am pleased to be joined today by Alan L. Friel, who is a great mind and a data privacy expert at Baker and Hostetler out in California. Alan, can you start off by telling us a bit about your background and your experience in the space?
Sure. My name is Alan Friel. I'm a privacy lawyer in the Los Angeles office of Baker and Hostetler. I've been practicing in the area of data protection and privacy for close to 30 years. It's been an exciting time for people in my field because there's been so much change in the last few years, and in particular in the United States. So happy to tell you about what the new laws are and what legislation is pending and how it differs from what you may already understand to be the case in Europe with the GDPR.
Great, thanks. Okay, so let's take a look at what our roadmap is for the next hour. So first, we'll start off with a general overview of CCPA. Alan is going to break it down into simple terms for us and explain what the law actually means and who it affects. And then we'll explore how we actually got here and where we're heading. Over the past few years, we've seen quite a movement against organizations taking advantage of our data. And a big result of this was GDPR in Europe back in 2018. And CCPA could be just the start of this in the United States. And then, of course, we'll dive into what CCPA actually means for you in HR and recruitment. You'll find out what precautions you do and don't need to take right now to be compliant. And we'll also discuss the penalties that are involved and when they'll start going into effect. And then finally, we're going to leave plenty of time at the end for you to ask your own questions. So again, feel free to start typing your questions into the box right now, and I'll make sure to get to as many as I can. And a quick disclaimer before we get started, this webinar is not legal counsel, but it is meant to be educational and beneficial. So while you will have the opportunity to ask Alan your questions for any decisions you or your organization make, always consult your internal legal teams. Okay, I always like to start off with a quick poll. So I would love to get an idea of where everybody is with CCPA at the moment. So let's get this started. Please let me know. Oops, sorry. Oh no, I just launched that poll. So I am actually going to have you tell me in the question box, if you can, right now, where are you at with CCPA? Do you feel like you have a really clear understanding, a general understanding? Have you heard of it, but not much more? Or is it totally new to you? So please go ahead right now into the question box and just let me know what you're feeling right now around CCPA. And I'll give everybody about 30 seconds. I see all of these are coming in already. Awesome. Okay, I see a huge variety here, but what I'm seeing for the most part is it's either totally new to you or you have a pretty general understanding of it, but not much more. So that's a really good place to start, especially because our next step here is going to be breaking CCPA down generally. So we'll talk about what this actually is, and then we'll go into more of the finer details about what this means for recruitment. Okay, Alan. So let's start off with the question, the literal question of the hour. Can you tell us what is CCPA?
So CCPA is the California Consumer Privacy Act. And that's a bit of a misnomer because the definition of consumer is anyone who pays state income taxes in California. Now that said, we'll talk about some delays on its enforcement in the context of business to business or human resources, but that's currently a 1 year effectiveness delay. But the definition of consumers is basically any California resident. What does the law do? It was designed to create greater transparency and choice for data subjects. It was inspired by the European GDPR, but it is significantly different. Companies that have gone through the GDPR process will have a lot of the work done, and at least insofar as that they have done data mapping, data inventories. They'll know what they collect, from what sources, how they use it, how they share it, where it's at, so that they can provide consumer rights, or data subject rights here called consumer rights, to it. But there are a number of significant differences that I can go into, both in the way data is described and the scope of what a data subject's rights are with respect to the data.
Okay. And to kind of break that down a bit more, which organizations does CCPA actually affect?
So CCPA affects any business except to the extent that it is engaging in transactions involving data wholly outside of California. So in other words, if you're a business that meets the threshold criteria and you are collecting, processing the personal information of California residents, except in a context that's wholly outside of California, then you're covered. Now, not every business will meet the threshold criteria. That criteria is currently $25 million in worldwide revenue, or collecting, processing, disclosing 50,000 pieces of personal information of individuals or households. Now that 50,000 pieces of personal information may sound like a relatively high amount, but because the definition of personal information is so broad and covers things like IP address or unique identifiers, that's about 138 unique visitors to your website every day that would bring you under. Now there is some movement to sort of push those numbers back a little bit. There may be some regulatory help that will minimize the personal IP address, for instance, being counted as personal information if it's not being associated with the user's activities. But most businesses of any size are going to be under the Act. Now, there's two other ways a business could be a regulated or covered entity under the Act. One is if it derives 50% or more of its revenue through the sale of personal information. So, in other words, data brokers, even if they're under the 25 million or 50,000 pieces of PI thresholds. And then finally, if you are a similarly branded affiliate of any company that meets the covered business requirements, you too will be deemed to be a business, even if you otherwise wouldn't meet the thresholds.
Got it. Okay, that's really helpful. I mean, when I was first exploring CCPA, the thresholds seemed like they were large, affecting larger companies. But I mean, having 138 visitors to your website a day applies to a lot of websites out there. So yeah, I see that it can affect almost every business. And even if a business doesn't operate in California, but we're getting job applicants from California, does that mean we do need to comply?
Yeah, that would be the case. I mean, I think the only way you want it would be if somebody was outside of California and acting in a way that didn't affect California, and the data processing never involved California. But it's going to be pretty rare. Those are going to be really the kind of mom and pop businesses that don't have any kind of doing business nexus to the state.
Gotcha. Great, thank you. That's a great way to start. So I think now is a good time to take a step back and look at the big picture. So Alan, why are we seeing these privacy laws like GDPR or CCPA pop up?
Well, I mean, GDPR is nothing really new. It's built on decades of European directives. It was codified into a regulation in order to sort of level up some European Union members and level down others, so that there'd be a more consistent approach to privacy throughout the EEC. European concepts of privacy come out of World War II and the Cold War. You know, in the remaking of Europe, privacy was characterized as a fundamental human right, and the European law has evolved based off of that concept. Privacy in the United States has never been a human right. It is in some ways a constitutional right when you're dealing with government actors. There are a few states like California that have made privacy a constitutional right in their state constitutions, but that was never really fleshed out in the law. It's not really something that's been an area of concentration in the U.S. And except on sort of a sectorial level. So we've historically dealt with privacy outside of the context of the government based on the sensitivity of the information and the type of industry or the type of activity. So for instance, in the HR context, the Fair Credit Reporting Act governs credit checks and background checks and requires consent and notice of any adverse actions based on report.
They won't let me log on.
Oh, okay.
And
Um,
and then we've got HIPAA for healthcare, Graham Leach Bliley for financial services, various other laws like COPPA that protects children. So we've not had an omnibus consumer or privacy scheme until this first California approach, and this is really driven off of public reaction to things like Edward Snowden and Facebook Analytica controversy, and a lot of big data breaches. So one of the things that we had in the United States that Europe didn't get until recently was data breach security laws requiring the maintenance of reasonable security and data breach notification. So we've really been concentrated more on security rather than privacy, and so with these increased data breaches, with these very public sort of privacy intrusions that have occurred, and with basically the publicity that's come with GDPR, there's been sort of a consumer movement to increase consumer access to their personal information and give them more control over its use in a commercial context. So what we ended up with in California was a ballot initiative that was going to be on last year's ballot, and it went far beyond what industry was comfortable with, and as a result, there was a very quick legislative compromise between the ballot initiative proponents and some industry groups.
Email address, or should I just use mine?
Use yours and see what happens. Should let you.
Alan, is there anybody else in the room with you? It just sounds like there's a lot of background noise.
No, I'm hearing that too. Coming
Oh.
from here though.
Yeah,
Okay.
I'm not
Somebody else has an
quite
open
sure. Yeah, let's see. All right, it looks like there's only us on. I'm gonna keep going, and if this ends up being a real big issue, we can call in. But thank you for that background. That's helpful to kind of understand why we're coming to this point in the US. Let's move to the next step, which is recruitment and HR. So CCPA for recruitment HR. If we have any listeners who are in Europe, you've already kind of addressed some of those privacy issues with GDPR. But let's take a look at what CCPA means and maybe what it doesn't mean, like how it is different from GDPR.
Right. So first, I'll talk about the current application in the HR context, and then we can talk about what's the difference between data subject rights as between CCPA and GDPR. So firstly, there was an amendment to the bill that would provide employers an additional year to prepare for CCPA. So as of the law went into effect as of January 1 of 2020. However, most of the provisions will not apply to personal information that is collected in the context of someone being a current or former employee, job applicant, independent contractor, or owner of a business until January 1, 2021. Now, there's some interesting things there. One of the things that's not included in that definition are partners, like partners in law firms or accounting firms. They're technically not employees, but they also generally do not own 51% or more of the business. And so there will be certain types of executive professional level doctors, dentists, lawyers, accountants, who by nature of having an equity interest in their enterprises, but not a majority equity interest, will not be exempt from the law. But the vast majority of what we think of as sort of HR data subjects is largely excluded for the first year, but not in every respect. So there's still the obligation to provide pre-collection notice to those HR data subjects with respect to what personal information is being collected and for what purposes. But that is a pretty minimal obligation compared to what is required in the way of very granular detailed notices for consumers and consumers' right to obtain additional information, access and receive copies of the personal information, cause it to be deleted subject to certain retention rights, and to prohibit its sale. So all that other big bundle of consumer data subject rights will not apply to most HR data subjects for the first year. One of the rights that does apply to HR data subjects is the right to sue a business in the event there is a security incident which causes unauthorized access to their personal information, in other words, a security breach, to the extent that it is attributable to the failure to maintain reasonable security. Reasonable security is not defined. We're already starting to see class action lawsuits filed in the wake of data breaches, and there will be a lot of litigation that sort of fleshes out what is or is not reasonable security. Now there are plenty of industry standards to use, but one of the big things that employers need to be doing right now is making sure that they assess and document their security programs. So in the event that there is an incident, that they've got support or evidence for having maintained reasonable security, the breach happening notwithstanding that. The other big thing is that this private right of action includes statutory damages, so you don't need to show any actual harm. You just need to show that there was an unauthorized access, and it includes minimum statutory penalties, which is going to attract the class action bar here in the U.S. Because you start adding up each data subject whose information was compromised, multiply that by the statutory damages, and you're looking at huge potential payouts for the plaintiff's bar. So
Yeah.
that's for in year one, it's this pre-collection notice and the security. We have no idea if the HR exemption will sunset at the end of this year or not. There's a proposed ballot initiative that would carry it out for an additional 2 years, but strangely as worded, it would appear that it would go back into effect in 2021 and then out for 2022 and 2023, which makes, of course, no sense. I think that's a typo. And they keep moving that in and out of the ballot initiative, so we'll see what happens there. Also, there were 24 state laws last year that were inspired by either GDPR or CCPA. Many of them included employee data. So none of them passed. Most of them were sort of held over to see what happens in California. And right now we've got 4 that are back on the state legislature's agendas. We're keeping an eye on Massachusetts, Virginia, Washington, and New York. And at least in their current drafts, they all exclude employee data. But again, unclear where that will land at the end of the year.
Got it. Thank you. I have a few fast questions from the perspective of a recruiter on applications that I think will help break down everything you just said. So first, under CCPA, it sounds like recruiters are required to notify candidates of their data collection, even if that might not go effect until 2021 and hopefully again beyond, or go back out in 2022. But either way, how can recruiters notify candidates of their data collection? Like, how should we do this?
Well, the pre-collection notice, like I said, is relatively simple to give. It is what are the categories of personal information that are being collected, and what are the purposes? There are one of the differences between CCPA and GDPR is this concept of categories. So there are 11 enumerated categories, and you have to use the enumerated categories. So the first thing that you would do is say, okay, what information are we collecting, either on the job application or through the recruitment process? Some things, like maybe it's transcripts, certified transcripts from the college. That would be one type of personal information. Social security number would be a different one. And so you'd inventory that data. You would decide which of those 11 categories are covered, and you would create a notice at or prior to collection, most likely on the application itself, that says we collect the following 6 categories of personal information, and then for the following purposes. The original regulations would have required you to tie each purpose to each category of personal information. You now no longer are. Well, if the second draft of the regs, which came out last week, they're still not final. If they stay where they're currently at, you would not need to categorize purposes to each category of personal information. You could just say these 6 categories of personal information for the following purposes. Now, there are 2 types of purposes. There are business purposes and commercial purposes. In the context of recruitment, I think it would be rare for there to be commercial purposes, except maybe in the context of something like a temp agency or a recruitment firm. But most of the purposes for the business itself are going to be its internal business purposes. And again, there are categories of business purpose. And so there are 7 enumerated categories of business purpose. In addition, you're allowed to create new categories of business purpose if you describe them in a way that is understandable. Business purposes are internal operational purposes. Commercial purposes are where you're essentially using the personal information for a non-internal purpose in order to commercialize it for your own benefit.
Okay, great. And then I have a few other quick questions, short answer questions. So short answer, if my organization only notifies candidates who selected California as their state of residence, will I be compliant?
Yeah, so you can rely on someone's self-identification. Again, it is about being a taxpayer, not being actually physically in the state at the moment. So I would caution against relying on just what address somebody put down as their mailing address. But you could have people self-select. Are you a California resident? Are you a California taxpayer? One or the other. They're essentially the same. And if so, provide the notice. But most of our clients have just provided, because the pre-collection notice is simple enough, they've just put it on all the applications and put it in all the employee handbooks and the other places that they would give it, rather than trying to distinguish between who is or is not California resident. Although it's permissible to do that, and we do have clients that have.
Okay, got it. And then another short answer question. So to notify these candidates, we have to put it in the job application. Can we still source candidates? When we source them, do we have to then like notify them that we are using their information, or what does that look like?
Well, the pre-collection notice is done at or prior to collection. And it just, like I said, you should describe all your contemplated purposes, any purpose that you're intending to do. Now once you've committed to that, you cannot expand the purposes without notice to the data subjects. So you'd want to be as broad as possible in your pre-collection notice. And one of the things too is there's going to be a different set of purposes. There's going to be a different set of information and a different set of purposes in the context of a job applicant than there will be as an employee. So a perfect example is employees may be subject to biometric collection for fingerprints for security access in the buildings. By the way, there's a bunch of specific laws about biometrics. Be really, really cautious there, particularly in states like Illinois, New York, Texas, and Washington. That's outside of the scope of today's conversation. Sensory data, closed circuit television, that's probably not going to apply to most job applicants, but probably will apply to most employees. So you may find that you have a different pre-collection notice as part of the onboarding process than you had in the job application as part of the recruitment process.
Okay. Great. Well, that is a good segue into our talent pool. And then after this, we're actually going to talk about briefly the current employees again. But say a candidate asks us for the data that we hold on them. Under CCPA, do we have to give that to them, like the data of like the feedback from the hiring manager during their interview?
Not in calendar year one. And you have put your finger on the issue that has caused so much reaction to this. There are already laws that provide employees and job applicants to certain information, their employee handbook, the result of a background check, etc. And so what CCPA would do if it goes into full effect for employees is basically provide far more access, essentially pre-litigation discovery for disgruntled applicants or employees to go on fishing expeditions to see if they can find anything to create an employment lawsuit. And so the argument has been that that was not the intent of the law, that the intent is really to address consumers, not employees or job applicants. The contrary argument is that this is really like the EU, where we care about data subjects regardless of the context in which their data is collected. And that continues to be a hot debate here.
Got it. Okay. We'll keep our finger on the pulse there. Do we need to delete our candidate database after a certain period of time? Like, is there a certain amount of time we can hold on to their data?
So not under the CCPA, unless the full consumer rights go into effect, and then consumers have a data deletion right request. That said, a company, a business can continue to retain it for legitimate business purposes, such as record keeping, pre-litigation preparation, taxes, things like that. So even were it to go into full effect, you would have the ability for certain purposes to retain copies. You would just have to limit its use for that retention purpose. That there also, however, may be some data minimization and retention rights that come into play with some of these new state laws that are under consideration, or with the ballot initiative. But at least for right now, there are no limitations on retention for the HR data subjects.
Okay, but what it sounds like you're saying is that we couldn't use our existing talent pool and then, market a new product to them. We have to use it for what we collected their data for.
Well, once you do, if you were to start marketing to them, then you're now collecting outside of the context of someone being only an employee, current or former employee or job applicant, right? That's going to be a different use case. And even if you originally collected it for the HR use case, once you start using it, that's going to be deemed a collection activity, a new collection. And now you've converted them into consumers. And one of the tough places to sort of draw the line there is going to be with respect to something that is arguably more of an employee benefit than it is a marketing. And you have to sort of look real closely to see, is this really marketing, or is this just communicating employee benefit options?
Right. Yeah, it can get a little fuzzy, especially if I were a candidate that applied to one particular job and didn't get it. If a recruiter is then marketing other jobs to me, is that like a consumer relationship, or is that still under recruitment?
Well, see, and that's going to be that's the tougher question, is for commercial recruiters as opposed to businesses, internal businesses, and we don't really have any guidance on that yet, and we'll have to wait and see. There's been nothing in the regulations about it, and we'll have to wait and see if we get any guidance from the Attorney General's office on that.
Okay, thanks. Let's quickly touch upon tools and technologies. So under CCPA, I'm required to maintain reasonable security. So what does that actually mean? I know you said that it's a little fuzzy.
Right. So, there are plenty of standards that apply to maintaining reasonable data security. All of these standards, I think, are going to be relied upon by companies to establish that they've maintained reasonable security. To the extent that you're having third-party outside audits of your security practices, and you've undergone penetration testing and testing for phishing, and you're meeting sort of the industry standards for good security hygiene, and you've documented that, and you've remediated your failings, and you've got ongoing training and education of the people who have access to the computer systems and to personal information. That's what you're going to have to show, and it's all going to need to be documented so that you can establish that, yes, in fact, you did all these things and you met the prevailing industry standards.
Okay. And then we've also looked at some tools. Workable is an applicant tracking system, and applicant tracking systems can help you make sure you notify your candidates in the job ad across all job ads and across all job boards. And then also like HR systems, you're able to notify all employees digitally of what we're using their data for. Are there any other tools that you recommend organizations consider to protect themselves against these penalties?
Well, like I said, from a security point of view, having third-party independent consultants come in and assess your security is highly recommended. There are all sorts of security measures and tools that the IT security folks are going to be employing. That's all going to sort of be in the background. Most HR professionals are not even going to be aware of it. Sort of one of the things that is going to fall squarely on the HR teams is the employee training, to make sure that employees understand what their obligations are with respect to data security, how they can avoid things like phishing attacks, clicking on emails that would infect their systems with malware or otherwise, or some of these other phishing attacks where we see a lot of situations where someone is purporting to be an executive in the company and gets a lower level person to give up their username or their password, or even to transfer money to them. And so it's sort of these common sense educational programs and policies that'll be in large part the HR team in conjunction with the IT security team to make sure that reasonable efforts are being made to educate people about data security.
Great, thank you. And we've already talked a bit about HR and existing employees, but I think it's good to reiterate, I especially see there's already a lot of questions coming through about existing employees. Does CCPA affect any information we currently store about existing employees and ex-employees?
So, like I said, right now there's only the security private right of action and the pre-collection notice. So for your existing employees, there's no need to have given them pre-collection notice prior to January 1 for the data and the purposes that existed prior to January 1. However, you will likely be continuously collecting personal information from your existing employee database. And so you're going to need to provide pre-collection notice with respect to that new and ongoing data collection. That can be done through the HR intranet. It can be done by pushing out an email notice to the existing employee database, by issuing a new policy, updating the employee handbook, and so forth. But yes, for your existing employees will need to be given new notice, or given notice with respect to the new collection and any new purposes. Also, again, if the full consumer rights apply as of January 1 of next year, then they're going to have the right to access, copy, and delete. That, however, access and copy would be on a 1-year trailing period, so older data would not be in scope. However, the deletion right is not time limited. The access and copyright is based on a 1-year look back from the date of request.
Okay, great, thank you. That's helpful. All right, so we did touch upon it a bit at the beginning, but can you please outline, one, how much are the penalties going to be for noncompliance with CCPA? And what are we looking at for dates? I know it's a little confusing, but when can we expect penalties will be enforced for HR and recruitment?
So the law went into effect on January 1. The implementing regulations are still not final. And last year, the legislature amended the bill to say that the Attorney General cannot enforce the law until the earlier of July 1, 2020, or 6 months after the date the regs are final. That pretty much means July 1 because we're already into February and they're not final yet. So the Attorney General has the exclusive authority to enforce the privacy provisions of the law. So that in the context of HR for this year, that means the pre-collection notice. However, there is no delay on the security breach private right of action. So we're already seeing class action lawsuits follow security incidents that have occurred in January and February. However, again, the privacy provisions, the pre-collection notice, the Attorney General could not bring an enforcement action until July 1, and the employees themselves do not have a private right of action. So all they can do is complain to the state, and the state could bring an action. Now, the AG has said that 6-month delay is not a safe harbor period, that he reserves the right to bring an action in July or August for noncompliance in, say, February or March. But the reality is, with 8 lawyers on his privacy enforcement team, it is probably unlikely that those are
the production floor to.
It sounds again like somebody is, they have their microphone on somehow. Let's have you keep going. Hopefully that doesn't happen again.
And then,
Alan, are you there? Sorry.
Yep. So starting July, the Attorney General can bring enforcement actions. He has to give notice and a 30-day opportunity to cure. Although, again, he said he doesn't think most things will be subject to a cure because the injury has already been done, right? But I think in the context of something like pre-collection notice, that may be the type of non-compliance that you may be able to prospectively cure. Again, not clear what the concept of cure is going to look like in practice. Then if the Attorney General is not satisfied with the cure, he can bring civil penalties against the non-compliant business, and those can vary each data subject each day. It's not clear how where the limits are on how what the multiples are, but if you look at comparable situations like data security breach, the AG has historically looked at counting as many incidents as possible to increase the total civil penalty pool.
Okay. Thank you. I'm going to keep moving. We're at the point that we can ask some questions. I want to make sure we have plenty of time because I have a ton of questions that have come through. First, I'd like to give everybody the opportunity to let us know if they'd like to see a demo of Workable or our partner for this webinar, which is Bamboo HR. So I'm just going to launch that poll and let everybody select their choice. And for those who don't know, Workable is a recruitment platform. Companies who use Workable get from their rec to offer faster because we give you more ways to find really qualified candidates. And our partner Bamboo HR is an all-in-one HR software, and we actually use them as our HR management tool here at Workable, and it works absolutely great for us. So I'm just going to give everybody about 30 seconds to answer this poll, and I'm also going to take a look at these questions. I think we have about 40 or 50 that have come through, so we unfortunately won't be able to get to everybody, but I'd like to give everybody the opportunity to reach out to me with any questions you still have. Workable has done a lot of work putting together resources on CCPA that can hopefully answer most of these questions. All right. Okay. Thanks, everyone. Let's keep this moving. Okay, Alan. So there's a lot of questions here. They're kind of all over the board. I'm going to just start selecting some and see how many we can get through. So do we need to actively notify the applicants in our talent pool who have applied prior to when the law went into effect? Like, do we need to send everybody in a talent pool an email to let them know that we have their data?
So not necessarily, only in the event that there is new ongoing collection or changed or new purposes.
Okay. Gotcha. Thank you. Next, let's see. How will the deletion right coincide with an employer's duty to maintain personnel records? Like, do we have to delete records if one of our employees asks?
So again, there is no deletion right for the first year, and assuming that it does go into effect for data collected from HR data subjects in an HR context, you would still have very, very broad retention rights. So record keeping would be a legitimate retention right. You would just need to limit the use of that data for those purposes.
Okay, thank you. All right. Next up, do we need to delete all emails about the candidate? Oh, sorry. Actually, we just answered that one. If you are a company that operates in multiple states, what do you recommend for resources for staying compliant in all locations, not just California?
Right. So the International Association of Privacy Professionals on its website is tracking all the state laws. Also, the State Legislators Association, which is all the state representatives and state senators, they have a professional association that has a website that is also tracking all the state privacy laws. So those are two really good places to go and check every now and then and see how this legislation is developing. And like you said, there's a lot of other HR related privacy laws, like tracking vehicles with geolocation tracking, biometric collection that require express consent, and employees in some jurisdictions have the right to opt out of that kind of collection and use. Those laws are also going to be tracked on those sites. And so be aware of not just these sort of big picture state privacy laws, but the privacy laws that affect particular intrusive use. And of course, there's the Federal Fair Credit Reporting Act and the state equivalents that govern things like background checks and credit checks.
Okay, thank you. This next question we kind of talked about earlier, but I've seen a few people have asked it since then. So when we are looking for job applicants, when we get job applicants that are coming to us, but also sometimes in-house recruiters will just actively search LinkedIn to find passive candidates. So these passive candidates won't necessarily go through an application process that notifies them of how we're using their data. Do we have to deliberately tell these people that we're seeking out how we're going to use their data?
All right, so that's an interesting question, right? So the pre-collection notice requires you to give notice at or prior to collection. When you're collecting from a third-party source, you don't have the ability to give that pre-collection notice, right? If you're collecting, let's say, from a data broker or from a public database like a LinkedIn posting. The regulations are still under consideration as the context of what, if any, notice needs to be given in that context. And at least the most recent set of the regs would substantially minimize a business's obligations there. Once you start engaging with that consumer, however, now you're collecting from them. And so that first reach out email is going to set up a process of exchange, which is a collection.
Okay, thank you. Next, it looks like we have a ton of questions that kind of reiterate what we talked about at the beginning, which is who does CCPA actually affect? So there's a couple questions here asking about like, so if my company doesn't have 25 million in revenue, does that mean CCPA doesn't apply to me? I know from what you said earlier that is not correct, but can you just quickly reiterate that for anybody who joined late?
Right, so it's 25 million in worldwide revenue. Collects, processes, or disclose 50,000 unique pieces of personal information a year, personal information being broadly defined. And so you can think of that, if you're thinking about unique visitors to your website, is about 138 unique visitors a year. Makes 50% or more of its revenue from selling personal information, which might affect some companies in ancillary recruiting that are like lead generators, for instance, or you're a similarly branded affiliate with a business that is covered. So, for instance, ABC Corporation is covered, and it has ABC distribution and ABC logistics and ABC consumer products. And even if one or more of those smaller affiliates is not covered, the fact that they use the ABC name would make them a covered entity.
Okay. Thank you. And then next, somebody asked, should I update my privacy policy saying that due to CCPA, we do not accept applications from California residents or taxpayers? Like, what exactly can the wording be there?
Well, there are a few companies that are basically that can get out of doing business with respect to Californians, but that's a rarity. Most companies in some way, shape, or form are doing business with California residents, the other thing I should say is that there is also a business-to-business communication exception for the first year as well. So it's not just HR data that has this limited application. And for the business-to-business communications data, you don't even have to provide the pre-collection notice. All they get is the private right of action for a security breach. But again, both of those exemptions are one-year exemptions, and I think that the train has left the station about data subject privacy in the United States, and we're going to see additional state laws in the next year or two, if not a federal bill within the next several years.
Okay. That's a good segue into this next question. You have a really good finger on the pulse of what's happening. You know, these new bills that were proposed in multiple states. Do you expect that over the next couple of years, some of these bills are going to go through? And how strict do you expect these could be?
I think I think that there definitely will be additional bills. Like I said, the 4 states that I'm keeping an eye on right now are Massachusetts, Virginia, Washington, and New York. At least as of now, all 4 of those would exclude HR data subject information in one way, shape, or form, which is a good thing. The Washington bill is more based on GDPR, the European law. And it got voted down last year, not by the industry advocates, but by the consumer privacy advocates, because they believed it had been too watered down during the amendment process. So I think we definitely will see other states follow on. And then if we end up with a patchwork of laws that are so different that it's such a burden for companies to comply, then I think we may see Congress step in and create a single standard omnibus federal bill. But right now, there's been no real traction at a federal law.
Got it. Okay. So we will all stay tuned with that. A couple more questions. So someone asked, so does business constitute a for-profit legal entity? And if so, does that mean that nonprofits are not subject to CCPA?
That's a really good question. And for the most part, that is true, yes. A business has to be a for-profit entity. So the government and nonprofits are not covered by this law. Now, what if you're a nonprofit entity and you're a service provider to a business? That was a question as to how that would affect businesses. And the regulations would propose or do propose that a nonprofit can be a service provider under the law if it meets, other than being a nonprofit, it otherwise meets the requirements of a service provider, which are you contractually commit not to use the personal information of your client other than for purposes of providing its services or certain other limited business purposes of the vendor, such as security and fraud prevention. So a nonprofit entity may be a service provider to a business, but a business that's fully regulated under the Act will never be a government entity or a nonprofit.
Interesting. I'm glad that question was asked. So it looks like we're just about to come up at the end of the webinar. I have one more question that I'll ask. Earlier, you talked about which businesses CCPA actually affects and how you can tell if your business is affected by CCPA. And one of the items was that if your company deals with over 50,000 items of personal information throughout a year, that you are required to comply under CCPA. And we talked about how there's about like 130 or 140 visitors to your website a day that would make you to be compliant under that. So is that visitors from California or anywhere in the US?
That is, as it's written, that is not tied to residency. And there's been a lot of controversy about that. But again, also the 25 million is worldwide revenue. It's not 25 million attributable in California. That said, the Attorney General has been silent on those issues. And there may be, grounds for arguing that it's intended to apply only to Californians. But that wouldn't be the plain reading of the statute. And I think that would probably be an aggressive position to take.
Okay. Gotcha. All right, Alan, we're coming right up at the end of the webinar, right on the dot. Thank you so much, Alan, for spending this hour with us and shedding some light on this issue. CCPA in general is really confusing and for recruitment, but I really appreciate you breaking down exactly what this means for us right now and what we can expect over the next year. So as we see some changes, maybe we can get back together in a year or so to see how this is all progressing.
Sounds great. Happy to be here with you today.
Awesome. Thanks, Alan. And thanks to everybody who joined us. Feel free to reach out to me with any additional questions. My email is carolyn@workable.com. Bye, everyone.
Why do you learn more about these?